For centuries, law in America was not just a profession, it was a craft. A trade passed down through apprenticeship, just like blacksmithing or carpentry. Young apprentices studied under judges and seasoned attorneys, learning through hands-on experience in real courtrooms. They didn't just read about justice, they practiced it. But something changed. Slowly, apprenticeship gave way to the ivory towers of academia. Law became a subject of study rather than a skill of practice. And that shift, one that has now lasted over a century, has left us with a broken justice system, one where many of those sworn to protect rights no longer know how to. In the 1700s and early 1800s, to read the law meant apprenticing under a judge or lawyer. You learned courtroom etiquette, how to draft a motion, how to defend a client, and most importantly, how to uphold constitutional rights. America's most iconic leaders, Thomas Jefferson, John Adams, and even Abraham Lincoln, were products of this apprenticeship system. None of them attended law school. Their training came directly from practice, from mentorship, and from real-world cases. The result? A judiciary grounded in craft, experience, and an unshakable connection to the Constitution. In the late 1800s, a transformation began. Harvard Law Dean Christopher Langdell pioneered the casebook method, turning the study of law into an academic exercise. Students read appellate opinions, dissected abstract principles, and debated legal theory. Soon, law schools replaced apprenticeships altogether. By the early 1900s, bar associations and universities pushed for formal schooling as the only path to practice law. The craft of law was replaced by the classroom. The apprenticeship, once the soul of legal training, vanished. Today, law schools across America churn out graduates who may have memorized constitutional clauses but have never drafted a real motion. They can analyze a Supreme Court case, but cannot conduct a proper trial. The system rewards memorization, not practice. Completion of assignments and passing theoretical exams, not real courtroom experience, decides who becomes an attorney. This one-size-fits-all approach has flooded our judicial system with lawyers and judges who know the law in theory, but not in practice. The consequences of this failed system are devastating. Many of today's judges, especially at the lower levels such as circuit court and general sessions judges, are direct products of this broken education pipeline. These judges frequently make serious mistakes that violate the rights of defendants. Why? Because they were never properly trained in the practical boundaries of their authority. Consider this. Judges issue gag orders far beyond what the law allows, silencing defendants and violating First Amendment rights. Judges hold hearings in the absence of defendants, stripping citizens of due process. Judges overstep their authority in civil cases, ignoring clear constitutional protections. Judges mishandle rules of evidence and procedure, sometimes to the point of denying defendants a fair trial. These are not rare accidents, they are systemic failures. Failures rooted in an education system that prioritizes theory over practice. When a judge doesn't know the limits of their own power, civil rights are the first casualty. Defendants are silenced, trials are mishandled, constitutional protections are ignored. The courtroom becomes less about justice and more about the unchecked discretion of undertrained officials. And because the pipeline produces more of the same, these flawed judges rise through the system, teaching new attorneys through their rulings, and the cycle of incompetence continues. Over the past century, this academic model of legal education has hollowed out the justice system from within. What was once a trade built on mentorship, wisdom, and craft has become a revolving door of theory-driven lawyers who lack the tools to defend rights or uphold justice. This slow decline has eroded the foundation of American law, and nowhere is this more evident than in the lower courts, where everyday citizens encounter judges who too often get it wrong. The solution is clear. America must return to mentorship. Apprenticeships must once again become a path to the profession. Judges and attorneys must receive hands-on training in real courts, under real supervision, with real accountability. If we want a justice system that protects rights rather than tramples them, we must demand reform. We must rebuild the pipeline, so that those who hold the gavel truly understand the weight of justice. Our justice system is only as strong as the people entrusted to run it. For too long, law schools have failed to prepare legal professionals for the reality of courtrooms. The result is a judiciary that makes dangerous mistakes, violating the very rights they are sworn to uphold. If we want liberty to survive, if we want the Constitution to mean something in practice, not just in theory, we must demand change, because justice is not a theory, justice is practice.